Chapter 24 concludes our review of negotiable instruments. Slide 3 talks about signature liability, which relates to how your signature can get you in trouble, so to speak, with your negotiable instruments. Let me guide your understanding here. Consider that a regular contract, requires your signature. What does your signature legally mean? What does it imply? We know two things. Your signature says, without saying so, that you have read and agreed to the contract. First, in other words, you agree to legally bind yourself to its terms. You don't need to say in a contract, I hereby agree, I've read, and my signature means this. It doesn't have to. It's implied by law. Second, you don't agree to any language after your signature. So where the signature is on the contract has legal significance. Anything below your signature does not apply. Thus, your signature on a contract makes you liable. Yet, how can your signature make you liable on an instrument? Well, with regard to promissory notes, if you're the maker of the note, you are primarily liable for that instrument. In other words, when the holder of the note, when the note comes due, will come to you first. If there are others on the note that have guaranteed your payment, the holder or the bearer can go after them too after going to you for payment. These are guarantors, and the guarantors bear liability too, but usually secondarily. As to drafts, such as checks, the bank is the accepting party. The bank is my drawee and is to pay the payee a sum certain as I ordered under the check. The holder or the bearer of the instrument then presents to the accepting bank or the payee listed the payment first. In other words, he does not come to me for payment as I wrote the check. He goes to the bank, the drawee bank, for payment. However, if the drawee bank or the payee bank refuses to honor the PTO instrument, I am next liable. I am secondarily liable. My signature says that once the payee bank refuses, legally speaking, I bear liability to make the check good. So let's add to this problem the endorsements or signatures of other parties, because other people have signed the check if there are endorsements on the instrument. Secondary liability falls on their shoulders as well, since they have signed the instrument. Remember, your signature says something. Endorsers, thus, are also secondarily liable. Let's consider a hypothetical. I write a check payable to the order of Adam drawn upon my bank account at First Bank. Adam then endorses, signs, pay to the order of Betty. Betty then endorses and signs, pay to the order of Cindy, who then presents the instrument to First Bank. Let's say I don't have sufficient funds in my account, and First Bank, who has primary liability, refuses to honor the instrument. What is Cindy to do? Well, she can say to Betty, because Betty signed, because of Betty's signature, make this check good. Indeed, all the parties who signed has signature liability, make the check good. Endorsers and drawers on the draft thus are secondarily liable, meaning they're second in line to pay out. However, signature liability starts upon proper presentment to the payee bank. Cindy has to present the check within a timely manner, which means usually 30 days from the time that she received it. Otherwise, the endorsees are not liable. The bank will dishonor, and last, Cindy has to give Betty and Adam and me notice that she's made proper presentment and the bank has dishonored the check. One more complication. Any endorser who is not liable if he receives notification later than 30 days after the endorsement that he gave. This gives the endorser a 30-day window where he could be liable and may have to pay the face value of the instrument if indeed it was not honored at the bank, the individual who is primarily liable. But here's an example to add to our earlier hypothetical. If I write a check to Adam, who endorses and signs pay to the order of Betty, and on day 1, Adam then remains liable to Betty and Cindy for 30 days. If on day 45, Cindy presents the check to the bank, which the bank then dishonors, she can't ask Adam to make good on the check's face value since his signature liability expired 15 days ago. Adam remains liable for 30 days after the presentment to the bank, proper presentment and notice. By the way, as the drawer who is also signature liability, my time limit is actually over a year. In other words, I'm liable for the check. I'm liable to make good on the face value for over a year. The exact limit depends upon various facts, but let me know by email if you have any questions about these calculations.